You're listening to podcasts from the Congressional Internet Caucus Advisory Committee, www.netcaucus.org.
We put together this really great panel of people, and let me introduce them real quickly in line. To my right, it's Sandra A-Stars, and I tend to say Sandra, I apologize, but Sandra A-Stars. She's with the Chief CEO of the Copyright Alliance. Next to her is Jonathan Band. He's with the Owners' Rights Initiative. And then we have Professor James Grimmelman, and James is with University of Maryland Law School. He's a professor of law. And Keith Cooperschmidt, he's the General Counsel of the Software and Information Industry Association. And the topic today is basically it's the idea is that there's a right of first sale, and that's been in our law and policy and our norms for many years now. The idea is that back in the day when I was younger, I'd have vinyl records and or even CDs like this, and I could sell them. Right now vinyl's back, and people are going to secondhand music stores to buy vinyl records of the audio files. They like that particular format. Once you own a tangible item, the first sale doctrine kind of says that you can give it to a friend, you can give it to you can sell it, you can resell it, and there's nothing that the publisher, the copyright owner, can kind of do about that. Same for movies, Ender's Game, which is actually really good. Mario Kart, a lot of fun. This is a really boring book, and I'd probably want to sell it. I don't know if anyone would buy it. And so that's the idea, that you can sell these things, but all of a sudden we're going from these kind of tangible items, these kind of chattels, into the digital realm. So the internet and computers, the internet is the most amazing copy machine ever created. It's shocking how good it is at transmitting and copying information. And now our entertainment are no longer really on CDs. I mean, they are. You can still buy them, but it's moving inexorably towards digital files. Our music downloads, our movie downloads, streaming music, eBooks. I got all my books on my eBook on my Kindle. I have all my music on my iPod. And what does that mean for this idea that why can't we resell the stuff that's on our iPod? Or why can't we sell the collection that I've amassed over the past 10 years from iTunes? Actually, it's been more like 7 years from iTunes, or 8 years. Why can't we? Should we be able to do that? Should that right to resell things, or give them, for the libraries to lend them out? Should we update that in kind of a new type of right that doesn't quite exist right now? And going through the legal stuff will be our panel. We're going to try to keep this not legalese or legal jargon, but kind of higher level, and kind of talk about the practical impact of what the transfer of all of our way of accessing creative expression and music, movie, games on the internet. How does that kind of what happens here and what happens going forward? I will say that one of the reasons we are looking at this is because other folks are looking at it too. The House Judiciary Committee is reviewing this issue. They held a hearing in New York on this particular issue not a couple weeks ago. The Copyright Office, they have said that they're going to look into reviewing this particular issue, as well as the United States Patent and Trademark Office. So we thought it'd be good to just have a conversation and kind of go through it. And I guess what I'd ask the professor, James Grimmelman, to do is kind of how did we kind of get here with regard to this right of first sale to actually sell our kind of tangible goods?
Okay. Hi. So traditionally, copyright has been a copyright. The author of a book has the right to control who makes and sells copies of it. And so that's the way that they get their economic reward that encourages them to write more, by making it illegal to print more copies and sell them without the copyright owner's permission. You have to pay them in order to do that. That's how their publisher gets its income. That's how they get royalties. That's what keeps the system going. But it was always been understood as a right to control making more copies. Once they put a copy out into circulation, you go to the bookstore and you buy it. Now, that specific copy is your property. And as you can with any other piece of property, a bottle of water, whatever else you own, it's yours to do with as you see fit. You can take it home and read it. You could put it out in the backyard for the birds. You could give it to a friend. You could sell it used. The only thing you can't do is make more copies, because that's one of the owner's exclusive rights. And this boundary is therefore a compromise between the copyright owner's intellectual property rights and the copy owner's personal property rights. The classic case that cemented it in United States laws from 1908, it's going to sound actually very timely. Book publishers were selling books, and they were concerned about a rapacious book discounter that was selling books super cheap to get people into its gigantic store to sell them lots of other things. They were concerned it was going to take over the book-selling industry. The year was 1908, and the massive discounter was Macy's. Bobbs Merrill, publisher of a book titled The Castaway, put a notice in the book saying the price of this book is $1 net. It may not be sold for less. We will treat selling it for any less as an infringement of the copyright. And so they sued Macy's, which was massively discounting books as a way to get them into their everything store. And the Supreme Court held that Macy's, as the owner of the copies it was selling, had the right to sell them free of claims of copyright infringement. The publishers could control the price they sold the copies initially at. If they wanted no copies to be sold, if they wanted to make $1 for each copy sold, they could sell them to wholesalers for $1. But once they had parted with the copy, they couldn't control it further. And so the two key components of that were in the 1909 Copyright Act and in the 1976 Copyright Act that we're living under today are, first, that this is only a right that applies to the owners of a copy. If I let you borrow a book from me, but you turn around and sell it, you weren't the owner, so you don't have a first sale right to do that. And it only applies to lawfully made copies. If you have a pirate printing press in your basement, you're just running off copies. They are born infringing. You don't have a first sale right to resell them. So the compromise is the copyright owner can control the making of copies and can make its revenue from selling the copy the first time at whatever price they want to sell it for. But after that, they don't control those specific copies. And that was the first sale compromise we lived with for many years, and I think the rest of the panel is going to be about some of the strains this is under in the digital age.
Okay, so right about now you're thinking, oh my God, I came here for a free lunch, and this guy's talking about a case from 1908. Why am I here? This is what's going on here. So my job is to explain why you are here, why this is all relevant. Tim did a great job of explaining sort of initially why this is relevant. I mean, if you look at a lot of the copyright law's provisions, most of them you go like, oh my God, this is giving me a headache, this is complex, or maybe you have to be a copyright attorney to understand them. For this provision, you really don't. Because this provision applies certainly to everyday people, okay? As Tim mentioned, it is the provision that allows you when you when you own, not license, not rent, but when you own a particular object, and the objects I brought, I'm considerably older than Tim, I guess, because I bought a cassette tape and a VCR tape. So I don't know what this says about me.
It says old school. That's what it says.
This is old school. Actually, don't copy that floppy, which you can watch on YouTube. A little plug for our very, very old video about floppy disks. But anyway, and it allows you to give it to somebody to throw it away and do whatever. And that's things that we all do every day, certainly in the recent past. So let me now, though, get you in my little DeLorean time machine, a little Back to the Future reference, and explain why this is relevant today. And the reason it's relevant is because of changes in business models and changes in the type of products that you are buying or licensing. And there are three issues, and I'm going to try to cut them up and slice and dice them into different slivers so you can better understand sort of what we're going to talk about here on the panel. The first issue is what's called the domestic versus international exhaustion issue. Okay, I'll be very brief on this. This is the basic issue of does the first sale doctrine apply when works are made in the United States? Or does it apply regardless of where the works are made and sold? Okay? This is an issue because it came up in a Supreme Court case back last year, March of 2013, in Kurtzing versus John Wiley. Okay? In that case, the person had books that were being shipped, made and sold in Thailand and shipped into the United States where they were sold for a lot less on eBay. We're not talking about that issue here. That's one of the few issues we won't really, you may hear us get into it a little bit because you can't ignore the international implications of these issues, but basically we're going to try to stay away from that. The other two issues that come up in the context of the first sale defense, and I should clarify, it is a defense to copyright infringement. It is not a right. It's not a right that anybody has. The copyright law grants a distribution right, and the first sale defense is an exception to that right. So it's not a right. But the other two issues are, the first one is license versus sale. Okay? So it's called the first sale doctrine. So if you're licensing something, does the first sale doctrine apply? The answer right now clearly is no. There is no doubt about that. The question that comes up, though, is when is a license, and when is license really masquerading as a license and is really a sale? Okay? And that's the issue that came up. We have decisions in the European Union. I think it was maybe not last year, maybe it was 2 years ago at this point, called the Oracle versus Ubisoft case, where they said, well, even though Oracle's licensing their software, you can resell that license. We have a completely opposite decision in the Ninth Circuit, actually two decisions in Autodesk versus Werner versus Autodesk, and Adobe versus Kornrumpf that just came out last week. And so that came to a totally opposite decision. And then the third issue is the digital first sale, what we call the digital first sale issue, which is, does the first sale doctrine only apply to tangible copies? Okay? Or should it also apply to your digital copies? More and more people are purchasing digital music, digital movies. Can you digitally transfer that similar to what you would have done in the physical world with this very, very old VCR tape or this cassette tape? And this came up in the context of a case you may have heard about, the Redigi case, having to deal with iTunes Music, and I know we'll talk about that later, so I won't get into that. So we're going to focus today's panel on digital first sale, which I just mentioned, and then the license versus sale, that sort of how that butts heads over time. And what we'll do in that context is focus on really one of the reasons why this is significant is the move from ownership to licensing. And I'll sort of stop there and put a pin in that. We'll revisit that in a moment, but I'll turn things over to Tim or Sandra, whoever's.
So I guess I can jump in and give a little bit of a practical impact, and maybe stepping in from the move to licensing as being much more interesting these days than ownership. I think if you look at what consumers are doing currently in the marketplace, innovation is happening in the digital economy more by services that are based on providing access to goods rather than sales of goods. And that's happening all across the board, whether you're talking about entertainment products or whether you're talking about normal, tangible consumer goods. So think about the consumer preferences, particularly amongst younger users. Zip cars are really popular. Bike share programs are really popular. People are turning to gifting and acquiring experiences rather than tangible goods. All these sorts of things in the physical world are also happening in the online world with consumers and how they engage with entertainment products. Rather than being interested in acquiring all of those tangible products in the real world, consumers are much more interested in acquiring digital products. And not only that, they're demonstrating a preference for acquiring subscriptions to streaming services rather than downloads. And downloads, I think, are much more equivalent in feel in the digital world to these tangible products than license-based products. So, what does all of that mean? Why do people do this? The benefits, at least to me, are obvious. You're not buying rights that you don't need or want. You're not paying for things that you're not going to use. You are engaging with the offerer in figuring out what exactly it is that you're going to end up getting from that deal, and you're not taking on responsibilities for physical objects that you're not going to want to maintain over time and use over time. In the creative sector, with entertainment products, it's led to much more innovative services, much more interesting ways to engage with products. There are also very kind of long-standing practices that have existed in the creative world that have always been license-based. And that's a very important thing to keep in mind, particularly it's been true in the software world, but I'll talk just for a couple of minutes about the visual arts world. Photographers and graphic artists and illustrators almost always deal with their clients on a licensing basis rather than a sales basis. And so some of the proposals that you hear in the context of a discussion of digital first sale doctrine suggest that if something looks like a sale and is deemed a license, we should treat it like a sale nevertheless. And so you'll hear people say, well, if it's a transaction that's a one-time transaction, there's no follow-up service from the licensor, and there's a single set price for it, we're going to call that a sale, not a license. But let me give you a example of where that happens all the time, and nobody actually thinks that they're buying the good. Stock image licensing. Getty Images, Corbis, and hundreds of other small stock image licensors exist across the country. These entities do online licensing all day long. They serve a diverse array of businesses, from individual bloggers who are totally non-commercial to Fortune 500 companies, and they have to be super flexible in how they deal with them. They have to be able to offer a variety of license models to serve that vast array of businesses, and they have to be able to negotiate those licenses online in a matter of seconds, because Getty, for instance, is licensing 300,000 images a day, which equates to more than 2 images per second. So if you're doing that sort of volume transaction, you're not going to be having individual negotiations online with a person. Regardless, I think nobody has ever had a thought as a consumer engaging with Getty to get an image to use on their blog or to use on their website that they're buying an image that they're going to have a right to then resell or license to others in competition with Getty or in competition with the photographer who took it. But that's the absurd effect that some of these proposals would ultimately have.
Right. So the expectation is that you're an iStock photo and you want to use it for your web page or something, and you license it for that purpose, and you're just not going to print them out and sell copies of the actual physical paper picture on the street. People understand that. I guess the question is practical effect is so when on iTunes when I download a song for $1.29, did I buy that? And it said buy, right? Amazon MP3s, Amazon audio on demand. It says buy, and I buy it. I have a bunch of things on Fios that I've bought, like Frozen, that movie Frozen. It said buy, and it was like $30 or something, and I bought it. And then, can you go through some other examples of what right now what we're dealing with, and am I buying that? Is that a license? But if I buy it, what rights do I have in it?
Right. So I guess I would say you can always come up with examples of things where in a given consumer offering, I might want a different consumer offering or something that, to me seems better. So, when I started first reading the New York Times on my iPad, I was frustrated. My husband and I had one iPad between us, and so we used to sit around on a Sunday morning and share sections of the New York Times, and, we didn't have to buy 2 newspapers, and we shared it back and forth, and all of a sudden we couldn't do that anymore. But, ultimately, we decided that the better consumer option for us was actually the digital version that we were getting, because it also meant that on a snowy morning when we're sitting, snowed in, nobody had to get up and trek to the store to get the New York Times. And, when we were traveling, we'd get the New York Times wherever we were without having to, go out for a visit to, the international newsstand and that sort of thing. And so we rationalized, yes, there's a bunch of things we didn't like about this offering, but there were more things that we liked about it, and so it was worth it to us. I think the same thing is true for issues like the right to resell, the right to inherit. When I'm engaging in a 99-cent online transaction to purchase an iTunes file, I'm not thinking about, am I going to be able to pass this file on to my heirs? I think it is a legitimate question to raise, but honestly, I don't think that's how consumers are voting. And when you vote with your pocketbook with services that consumers are expressing, a affection for and support of, I think that's how you really demonstrate whether people, like those services or don't like them. And services that do a good job in satisfying consumer demand will survive, and those who don't won't, or they'll have to, change their business models. I do think, businesses need to do a good job in disclosing what people are getting, but I don't think the copyright law is the place where you should make those requirements. There are, consumer protection laws and other laws that can be brought into play rather than the copyright laws.
So as the internet is transforming everything and disrupting all of these notions of how we've done things in the past, and as we go from tangible items to kind of digitized items, and the concept of ownership is changing, what's the problem? It looks like people are getting licenses instead of sales, and where is this all going, and why should there be a problem? James, Jonathan, maybe you can weigh in on this one.
Sure. So, thanks for the question, Tim. So, I guess the problem comes in several different ways. One is that a lot of consumers really do think that they are buying these objects. As you mentioned, when you're clicking on iTunes, you think you're buying. It says buy now, and so
did I buy it?
Well, that's a good question. Because
I don't know.
Chances are that that there's all this fine print that says you really didn't buy the copy, that that you just leased the copy, and so and this gets to Sandra's point, and I think at the hearing a couple of weeks ago, there was a professor from UCLA who was, his point really was very much that the disclosures need to be a lot clearer and a lot simpler for users. Certainly when you rent the zip car, you're not buying the car, right? You're just renting it, and that's very clear. But when it says buy now and you think you're buying it, so there is a definite consumer expectation issue that comes into play, and I imagine that there's a lot of you who have bought quite a lot of digital media, and you think you own it, but then you might be getting less than what you think for, and part of it also is a pricing issue. Meaning, certainly, when you rent the zip car for an hour, you don't pay. You're only paying whatever it is, $10, $20, whatever it is, a relatively small amount, a price that reflects that you're just renting it. But a lot of the pricing issues that we see, the pricing models, you're paying a lot of money. You're certainly paying as much money as that you would think. And this has been happening in the textbook context, where the price that's charged, is a couple $100. So you think that the consumer expectation is, given that pricing, that you are buying something, and then you might turn around and find out that you haven't. So that's there is a whole consumer expectation issue that is a function of the labeling and the pricing that I think needs to be dealt with. Now, how it's dealt with, I don't know. I mean, whether it needs to be consumer protection law or copyright law, whatever. I mean, there is an issue here that definitely needs to be dealt with. But
so
the
I guess what you're saying is that when it is if it licensed or you're buying it, and the fine print or the print is kind of the end user license agreement, right?
Right. That ends up being very one-sided, very unfair to the consumer. I mean, I think that there is an issue that needs to be dealt with, and again, exactly how it's dealt with or where it's dealt with. My coalition is not sure about, but we know that there is a problem here that needs to be addressed. There's a related problem that's maybe narrower because, as you can see, this digital first sale issue is kind of a big issue with a lot of consumers on one side and technology companies that want to offer these services, and then you have rights holders that want to maintain control. There's a narrower issue that my group is focusing on that I just want to raise, and we can talk more about it later. And that's that you have often hardware products, and so I see a lot of you have laptops. But within the hardware products, you have software. So that's digital. And certainly, you expect that when you buy, let's say, a computer that has an operating system in it, that you should be able to dispose of that computer or sell that computer. The problem that in some cases, some manufacturers are saying, okay, well, you own the hardware, but you don't own the software that's essential to its operation. And so you're allowed to transfer the hardware, but you're not allowed to transfer the software. Your first sale right, because you're not the owner of the software, you're only the owner of the hardware. They're saying you don't have the first sale right to transfer the hardware. And then that is a problem for you if you want to sell it. It's a problem for the purchaser on the other end. They buy it, and then they're saying, well, that they don't get the security patches, the bug fixes, because the manufacturer saying is, oh, you don't own that piece of software.
So maybe we can come back to that essential software thing, but I think what you're talking about is like devices like a Nest thermostat or a Nest smoke detector. Anybody have one of these in their homes? They're so awesome. But they're really technologically advanced and they have software inside of them. And what you're saying is this is still in the wrapping, so I could sell it to any one of you you all want them now, right? I could sell it to any one of you, but the question is, and this is not specifically to Nest, but do you get software updates that come with this device?
Right. I mean,
that is the question you're raising.
That is right.
Okay.
It's whether you in fact that I'll have the right to sell that. I mean, you have the right to sell the device, but do you have the right to sell the software if they say that you only license the software? So it's a transfer issue, and it's also an updates issue. I mean, so it's right. But that's a much narrower issue, of course, than this whole big, something that deals with all the digital stuff.
Yeah.
And do you have the right to transfer all of these digital products that you are maybe not the owner of, but the licensee of?
Let me jump in with concrete points about two of the issues that have come up. One of them is that as more and more things have intelligence in them, like that Nest, the markets that let people share physical goods actually depend upon first sale. Cars have software in them. So if you said that the software in a car is licensed, not sold, and you never own it, then copyright owners could use first sale to restrict the distribution of cars, and Zipcar couldn't operate without the permission of every auto manufacturer whose cars it's renting. So that's a place in which first sale keeps markets for physical goods clear of copyright claims. The other thing I'd point out is that when we talk about buying, the right to transfer things to other people is one part of the bundle that consumers care about, but it also is a kind of permanence that they care about. The fine print on a license for Frozen, when you bought that online, probably says that they can take it away at any point if they need to shut down the platform or if, for whatever reason, they decide to restrict your access to it, in which case you find that the movie you bought has vanished. The Federal Trade Commission investigated a number of companies that shut down the platforms that provided access to their media and sort of closed those all investigations with letters saying this could be a deceptive practice if you said the consumers bought it, but you kept it on a string so you could yank it back at any point after they paid their money. That's not the same thing as the consumer having a right to resell. And we might care about the good not being yanked away from them more than we care about their right to go to a used digital goods store and sell it there, but it's part of what people care about when they buy. I think one of the reasons that streaming services like Spotify feel fair to people is that they understand when you stop paying the monthly fee, your access stops. They understand that this is an exchange that lasts for a certain amount of time. You're paying for access during that time, and they're very clear on what the terms of that are. The expectations around buying digital goods aren't as clear, and I think a lot of the struggles right now are to try and figure out and explain clearly to consumers exactly what is and what is not included.
Go ahead.
So I think we've hit upon a point here that I think we generally agree with, which is that there is a certain level of consumer confusion at this point. And I think that's due in large part to the fact that, boy, are things moving fast. Business models are changing very rapidly. I know our members and I know other, companies that are in the movie industry, the music industry, and video game industry are all trying to create new business models to get their copyrighted products to the consumers in a way that they can get any content, anytime, anywhere, in any format or language. That gives consumers more choice, more convenience, more opportunity to experiment with things. But because of that, because of this dramatic change that's going on right now, things are moving from analog to digital, from digital sort of that you purchase to in the cloud being licensed. Things are changing significantly. Consumers are sort of being dragged along, and there is a certain level of consumer confusion. And we could stop at a point here and say, okay, here's how we should define this, but then we might get stuck. If we did that years ago, we might get stuck with these things, okay? And we don't want to do that, okay? We want to take advantage of new technologies and new business models. And so that can give these consumers more convenience, more choice, okay, to access these copyrighted works. There was a story I just heard the other day with one of the CEOs of our member companies said, software companies was talking and said, the future of software is DOS. And everyone looked at him, well, what are you talking about? It doesn't make any sense. Not for a disk operating system, but don't own stuff. Okay? That's where everything is going. Okay? In the future, I mean, there's tons of literature written, articles written about this. Consumers may own certain essential things. They may, things that they use very often they may own, but things that they only use on occasion, okay, which a lot of what we're talking about falls into that category, I think, but also things like fancy shoes, most jewelry, that pizza making set that you have, those type of things will be licensed in the future, if not already. Sandra mentioned zip cars. Go online. Look at Rent a Runway, where you can rent a ball gown. Now there's even a peer-to-peer sort of licensing models out there, where the stuff that you all own, you can now rent to other people. Go look at tool spinners, where people rent lawn mowers and tools. Snap Goods, where they rent other electronics. What I'm trying to get at here is there is a dramatic shift in the ecosystem. People are moving from ownership to, businesses and people are moving from ownership to licensing. Okay? And that's not just in the world of copyright. That's across the board. And to the extent there is consumer confusion in this area, it is across the board too. So it makes no sense to go and muck with the for sale doctrine, so to do something to change it so it applies to licensing, when this is an issue more about consumer education and consumers getting more knowledgeable, and obviously businesses and government helping them get more knowledgeable. It makes no sense to muck with for sale doctrine. This is a much bigger issue than that.
And I was just going to address a couple of additional points in terms of why some goods might be better to license digitally than to, buy digitally. And I suspect that when you, get a file from iTunes, you're actually getting a license. And why are you getting a license rather than a sale? Because you have the right to get it on 5 or 6 different devices and access it rather than just on that one, just one copy. You've got the ability to call up iTunes when your computer crashes and you lose access to it and get it, reloaded. You've got the ability to get some troubleshooting help from them in various instances, and that's all managed by a license agreement. So you've made that decision that those sorts of abilities and interactions as a consumer are valuable to you by using iTunes. Maybe the ability to resell the file is something that's of interest. That can also be managed through a license agreement as well. If there is sufficient consumer demand and consumers make the case that they're willing to pay a premium to have a file that can be, resold, I'm sure somebody can come up with a business model that encompasses that.
And this is all playing out as we speak. We had a conference call just the other day to kind of go over what topics should we cover. And the question, Apple just bought Beats, Dr. Dre's Beats, and part of the reason they say is that they have a streaming service that Apple wanted to move from downloading songs to more streaming, and so that was a clear indication that we're moving to a licensing regime. And as we were on the call, literally Amazon announced that their music service would go from they'd launch a streaming service as opposed to downloads that they have right now. So this is all playing out, and you and Keith are suggesting that people they don't want to own stuff, and they would just want to have licensed. But there's kind of my thing was when I started accumulating an iTunes library of music was I wanted to own it. I wanted to own it. I wanted to be in possession of it, and I wanted to put it on my hard drive, so it's in my hard drive here. And I wanted to keep it, and I wanted to have the files and be able to access them and see them, and that was my decision. And at the time, there was Rhapsody. I think it's owned by Yahoo now. It's actually a great streaming service, really good stuff. You could build all your different playlists. It's really awesome, but it's a monthly fee, and I decided, I kind of want to own that stuff, right? But that was my decision.
And so if I may, this is getting back to sort of what Keith was saying, but also what Tim and Sandra, or what you're all saying, is that yes, there are many options available to consumers, and that's a good thing. And more consumer options are always a good thing. But we shouldn't forget that a lot of the world is going to remain very tangible, and there's a lot to be said for ownership and the principles of ownership that Tim's alluding to. And also, we shouldn't think for a second that even though we're talking about all these wonderful choices to consumers, a lot of these choices maybe in the short run are cheaper for consumers, but in the long run will be a lot more expensive for consumers, right? And so everyone. It's good for people to have choices and to have options, but they really should have an option, meaning there should be an option. Do you buy it or do you rent it? And so there's that article in the paper the other day about, the perennial issue that I'm sure a lot of you who are younger in the audience, are thinking, do I buy an apartment or buy a condo or do I rent an apartment? And there's all these trade-offs, and, it's different for everyone. And does it make financial sense? And then it's also the sense of the pride of ownership and all the rest that goes with it. I mean, certainly for another one of my clients, library associations, I mean, they're moving into this world of eBooks, and you have to often the library that is lending the eBooks, I mean, they get that on a license basis from the publisher. Believe me, those are a lot more expensive. It's a lot more expensive over time for the library to license the ebook from the publisher than to just buy a copy. And that's the world. There's a reason why vendors are very excited about this licensing model, because they have figured out that over time they're going to make more money. So that's not to say that's a bad thing. But we just need to be going into this with our eyes open and make sure that consumers, A, have the choice, and B, know what they're getting into. And again, certainly if they think they're buying something, they should have, the ownership rights that go with that.
So I'm not sure, actually, that consumers are paying more in a licensing model now than they are in a ownership model. Going back to my New York Times on the iPad example, when I subscribed to the New York Times living in New York City, 4 or 5 years ago, and I got it delivered to my doorstep, and I traveled for business a lot. It would still be delivered to my doorstep. I would buy it a second time when I was in Los Angeles or wherever I was, and I'd probably pay $7 for it there because it was in Los Angeles, and I'd get a lesser copy because it was the regional copy rather than the New York Metro copy. And so I've paid for it twice. When I get it on my iPad, I have the copy that is the same copy nationwide. I get it wherever I go, and I have access to it, without having to, pile up copies at my doorstep. I think it's a much better consumer proposition, and it's actually cheaper for me than what it was before. And I think you find that with a lot of other offerings that are in the marketplace. If consumers aren't getting a better deal, they're not going to take the offer that they're being made. The bottom line is, there may be offers that I would want to get or you would want to get, and the marketplace will accommodate to what consumers tell the marketplace. So rewriting the copyright law to force by dint of what Congress thinks the consumers should get is not the way to accomplish it. We shouldn't be rewriting the first sale doctrine to force the Internet to act like the analog world.
So let me ask you a question to the panel. This is I have an iPod here. It's like one of the first generation iPods, and it's packed with like Van Halen's greatest hits and a lot of other 80s greatest hits. I can sell my iPod. It's not worth, the hardware is not worth that much, but for Van Halen fans, it might be worth quite a bit. Can I sell this and my songs on it on eBay or like to someone in the audience here? Can I legally sell this iPod lawfully?
I do not have the ability, or I don't speak on behalf of the music industry, so I will speak on behalf of who I represent, which are software companies. And if you had
let's assume that I bought these MP3s that I downloaded and bought legally from iTunes were actually, I bought them and they're MP3 files.
In the software world, if you were to purchase a license to use the software and install that on your hard drive, the license, obviously it depends from license to license, each company has different types of licenses, but as a general matter, you can transfer that software to somebody else, but you have to go through different procedures to do that, okay? Now, you will have to contact the software company. So for instance, they're not feeding the updates to the person who sold you the hardware with the software loaded on it or something like that. So there are these procedures that you need to go through, but not all software is transferable, and for good reason. And I'll give an example, which is academic software. Academic software is software that is sold, the license is sold to teachers, and to students and other people in academia. And this is fully functioning software. So the only thing that's different about it is the fact that there is a license that controls the transfer of that software, and the fact that license also says you can't use it for commercial purposes. And in turn, that software is sold for a dramatically reduced price so that students and teachers can afford it, okay, and afford to use it. So there are restrictions on transfer, but they're not wholly. It doesn't say you can't transfer it at all. It just says if you're going to transfer it, you have to transfer that software to other students and other teachers. I think that's totally legitimate. Now let's say we all of a sudden muck up the first sale doctrine and we change that so that those license terms are no longer enforceable. What's going to happen is students are going to turn into big business makers. They're going to buy that software, and then what they're going to do is they're going to resell it. Okay, and make a profit. Okay, what's going to happen is software companies are going to stop offering academic software.
So
that's not a good thing. So that's the software industry's response.
Yeah, a student textbook on electronic textbook. You buy it. It usually costs $30, but for students it's only like $10. They download it and immediately resell it for $25, like immediately. Is that that's the absurd result you're saying?
Yeah, I mean, textbooks is really an interesting case because you've got all these different models. You can certainly go out and buy the print copy of a textbook, but talk about an industry that is dramatically and rapidly changing. You've got these new e-textbooks where they come with tons of special features, things like embedded quizzes, dictionaries, glossaries, electronic flashcards, highlighter, markup options. I could go on. Okay, and there's tons of these new features, and it allows teachers to do things like monitor the students' progress, making sure they're understanding the material, develop these personalized plans. There's some wonderful things going on in the e-textbook industry, okay? But because these are really personalized textbooks at this point, they really shouldn't be transferable. And they license these textbooks. And there's a lot more money that goes into making those textbooks, too.
I have a few other questions and a few other things we want to get to. But let me I know that some people have some questions. I know Rob Pagararo is in the audience, and he always has a question or two. Question from the front row?
Yeah, I just wanted to get your reactions to how WIPO has dealt with the issue, because they've really already dealt with it in the Copyright Treaty and the Performances and Phonograms Treaty by essentially leaving the national law how to deal with exhaustion in dealing with tangible fixed objects, but by creating the umbrella solution where you have an interactive making available right and communication to the public right, it does not permit in any way exhaustion of rights in the online space. So anyway, it's not really a question, but your reactions to that. WIPO has essentially already dealt with this. And one other issue on software, just to point out the essential.
Yeah, in the larger context of what the WIPO is doing and international developments on copyrighted works and things like that. In the copyright space, what other jurisdictions do is actually pretty relevant. So sometimes Congress changes our copyright laws to harmonize with other countries, and so globally we're on the same page. The Digital Millennium Copyright Act was kind of done because there were some treaties that we wanted to sign, and we wanted to make sure that we were on the same page. So there's a harmonization effect. So what other countries do is not unrelated to how we would approach things going forward. Is that so? Anybody have any comment?
I would just say that Congress would be very surprised if they were to learn that the WIPO copyright treaty foreclosed its ability to consider this issue, and certainly that was when the U.S. negotiators came back and urged the U.S. to sign and ratify the treaty. They did not indicate that there would be a foreclosure of dealing with these kinds of issues.
So,
my only point was there was a reason why they bifurcated the issue between tangible fixed copies and intangible online transactions.
yeah, I mean, I think you're going back to what does the right apply to? Does it apply to the reproduction right? And if you're making a reproduction of a work, should that be excluded? And that's been the case from the very beginning. In Bobbs Merrill, the Supreme Court said, no, you can't make reproductions of works. The Supreme Court looked at, what is the motivation of the author? Is the author getting the value of the work that it has put out in the marketplace, or is it being, put in competition by, other works being reproduced and sold in competition with it? And so reproduction was not, permissible under the first sale doctrine. When the issue was looked at again in 1976, when Congress updated the copyright laws the last time, the first sale doctrine was not a particularly discussed issue. And in fact, the only place where it came up was when the display right was added for copyright owners, and it came up in that context as a need to limit the first sale doctrine to make sure that it did not impact the rights owner's ability to use its traditional reproduction and distribution rights as technology evolved. So it's not been a topic that's been considered really from any perspective, at least in Congress, other than is the copyright owner getting the benefit that it was intended to get under the copyright laws, under the constitutional directive to empower authors to create and disseminate works. I think if you look at what's happening now in all of these discussions around digital for sale doctrine, you've had the Copyright Office look at the issue in a very comprehensive report and conclude that it would be unproductive and dangerous to various digital models that are developing, and I think that's consistent with what you're suggesting. WIPO has also concluded. So
we have like 8 minutes left. Any other questions in the front row? And then Rob can tell me whether I can sell my iPod or not.
One of the fundamental differences I'm hearing when Sandra talks about the New York Times and Jonathan talks about and James talks about textbooks is there's a vastly different cost for the consumer, and they're also vastly different resale values. I mean, yesterday's New York Times doesn't really have much of a value, even if you bought it for $7 today. But if I spend $130 in my law textbook, I really would like to get something back for that, even if I'm getting a digital copy with it. And I know something recently just happened with legal textbooks that actually James was very involved with.
If you're spending $130 for a legal textbook, you are getting an incredible bargain. The prices have pushed past $200 for a copy, and the student could spend $1,000 for textbooks a semester. This is a major contributor to the cost of legal education. The publishers have been letting it be known quite clearly that they actually really resent the pressure that First Sale puts on their business models, because if a student has the choice of paying $225 for a new book or $50 for a book with somebody else's highlighting in it, they're going to go to the used market. And so the publishers have been very aggressive in trying to push digital copies as an alternative. And what we've seen in the marketplace is that students have largely resisted buying digital books because paying $180 for the digital version just doesn't include the bells and whistles, don't justify that $130 markup over the used copy. So they're making quite aggressive pushes to take away the physical option. One case book publisher is now pushing students hard to take a version in which they get a book. They have to return at the end of the semester to be pulped. That's how aggressive they are about trying to dry up the market for used copies. And this is one of the reasons why they're embracing digital distribution. No used copies to compete with the new ones to hold the prices down.
Right, and what makes it worse, of course, is like it's not like the student really has a choice. I mean, if this casebook is assigned, they have to get that casebook. They might be able to get away with an earlier edition of the casebook and then hope that they're not missing too much content. But it really doesn't work to say, you don't have a normal competitive environment where the student, the consumer, really has a choice to say, okay, I'm not going to buy that casebook at all, or I'm going to, buy someone else's casebook, right? Because this is what's assigned. And so that's why, you will find in various markets the whole consumer choice and the normal market forces fall apart.
It's interesting. I mean, this is the Washington, D.C. spin machine. How do we make it look like, even though we're trying to give the students and consumers what they want, we want to be stuck with, cassette tapes and VCR tapes. The option is still to get the print text, and it will be there. But these new digital texts, I have different numbers than James here apparently, so I guess we won't go into that. But these new e-textbooks are oftentimes, almost always, dramatically reducing the cost that the students are paying. And, like I said, you cannot ignore all these bells and whistles, which are beneficial to not only students, but also the universities and the teachers as well.
I know Sandra wanted to make a comment, but I think I have time for one more question. I promised you guys I'd get you up by 1. Rob, did you have a question back there?
There was an interesting discussion earlier about what sort of signals prices for digital items sent. I'm looking at the Mac App Store on this computer. It used to be Apple came out with a new version of iPhoto, and I would actually sell the old CD on eBay. Maybe a decent amount of money. Now I can't do that, but on the other hand, individual apps are so much cheaper. So my initial reaction is, I think I'm okay with this, but should I be feeling victimized?
I think it really, the answer, the typical lawyerly answer, it depends. So I think I wouldn't be surprised that in most, over time, in the long run, the market works usually, right? And so I wouldn't be surprised for most apps. I mean, you have a competitive environment, and it's good to have the competition between the Android world and the iPhone world. I mean, all the more competition you have, the better, and the more consumer, that will drive consumer choice. But you need to make sure that consumers know what they're getting, and that gets to the labeling issue we were talking about before. Are you really buying it? And then also, what do you do when you don't really have a competitive market, like with casebooks, where you're stuck, or the example I was giving before, where you have a lot of sunk costs. So where you have, you've already bought a computer, right? You've spent, several, and it's even worse. Let's say if you have a server, right? You're a company, you've invested several thousand, tens of thousands, hundreds of thousands of dollars in a server, and then you have software that's embedded in that, and you want to, then you do. The competitive market sometimes doesn't work in your specific situation, and you do have a market failure.
If anybody has I
mean, we don't have enough time to address everything that you said. I mean, there is a provision in the Copyright Act that allows the transfer of the software in the hard drive if the software cannot be copied. But there are other issues there that we'll get into at some other time.
And I wish I had more time to
Quick comment, please.
Okay. Oh, is it a comment or a question?
Quick comment.
No. Let me just. I did promise. I did promise you guys I'd get them out at 1:00. The last question I would have, I think you've kind of touched on the answer on this during your comments, but I got this question via email before I came. Was should we have this kind of digital for sale idea, and if so, what should Congress do about it, or should they not do anything about it? And that was the question that I got, and I'd like to just finish on that. If you guys could just weigh in really quickly on that.
Yeah, I'll start off and just add, as I think evidenced by my comments today, there's nothing that Congress should do at all for the digital for sale doctrine. If there's something that Congress should do, it should look at the Kurtzing case and fix Section 602, but we'll talk about that some other time.
And I would say that the Kurtzing rule came out just right, and that's the last thing Congress should do.
Right. And I mean, I said it during the comments, the options that consumers have today under licensing models, whether they're brand new ones or models that have existed over time in industries like the visual arts, are unprecedented, and we shouldn't be sacrificing those by trying to make the Internet act like the analog world.
Okay. James?
And Congress should make sure that first sale in physical goods remains and protect consumer expectations for virtual goods.
So I have. So anybody after the event, anybody wants to see me to buy a Nest thermostat, a really boring book on lobbying, and I have to get a legal opinion on whether I can sell my iPod. You can see me afterwards. I want to thank this great panel and thank the Congressional Internet Caucus co-chairs for supporting us. Thanks very much, folks.